All right, Keith, we're ready.
Okay. On this Thursday, October 22nd of 2020, we'll call to order the Alarm System Contractors Board meeting. Ms. Vest, could you do the roll call?
Thank you. Keith Harvey.
Here.
Scott Cockcroft.
Here.
Lou Richard.
Here.
Doug Fraker. Let the record show that Doug Fraker is not present, but we do have a quorum, Mr. Chairman.
Okay. Has everyone had a chance to review the agenda?
No, I believe this is where we were going to put Ashley in first. She needs to read necessity.
Okay.
Thank you. Yeah, as Cody said, I need to read the statement of necessity into the record. This is the regularly scheduled meeting of the Tennessee Alarm Systems Contractors Board, which is taking place via video conference in accordance with Executive Order 60, which is in response to the novel coronavirus pandemic. Notice of this meeting was posted to the board website on October 15, 2020. As there is not a physical quorum present, a statement of necessity will be read into the record. Pursuant to Tennessee Code Annotated 8-44-108B2, which states if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which it is based. Further, Tennessee Code Annotated 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. Once again, this is the regularly scheduled meeting of the Tennessee Alarm Systems Contractors Board. The purpose of this meeting, with members attending by video conference, is to discuss the agenda as posted to the board website. Voting will be conducted by roll call.
Thank you, Ashley. Keith?
Okay, are we moving on to the agenda now?
Yes, sir.
Okay. Is there anyone that, is there, everyone looked at the agenda? Can I get a motion on adopting it?
This is Scott. I'll make a motion to adopt the agenda as presented.
This is Lou. I'll second.
Okay, we have a motion and a second.
Okay, we'll do a roll call. Keith Harvey?
Yes.
Scott Cockcroft?
Yes.
Lou Richard?
Yes.
The ayes have it to adopt the agenda, Mr. Chairman.
Okay. We'll move along to the minutes. As everyone had a chance to review the minutes from the last board meeting, could I get a motion to approve the minutes?
This is Lou. I'll make a motion to approve the meetings from last board meeting.
Second by Scott.
Okay, we have a motion and a second.
All right. Keith Harvey?
Aye.
Scott Cockcroft? Scott?
Yes. Aye.
I'm sorry, I didn't hear you.
Yes.
Lou Richard?
Yes.
All right. The ayes have it to adopt the minutes from the 8/20/20 board meeting, Mr. Chairman.
Okay. Let's move along to the legal report.
All right, good morning. Had to unmute there. The first case on here, case number 20200545881. The summary is this complaint was extremely sparse with just said, quote, no QA, end quote, and had contact information for the respondent and apparent complainant. The named complainant is an employee of the respondent, and when contacted, he denied making the complaint. His contact information was also listed in our licensing file, so the complaint was forwarded to him for a response. He gave us information for the qualified agent, which was reflected in our licensing file, so the recommendation is to close.
Okay.
This is Scott. I'll make a motion to concur with council to close.
Do we have a second?
This is Lou. I'll second.
Okay. We have a motion and a second.
All right. Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richards. Richard,
Yes. Yes.
the ayes have it to concur with council.
All right, thank you. Moving on to number 2, complaint number 20200555021. The summary is the complainant stated that it saw respondent's page and made this complaint after he believed the respondent was engaging in unlicensed excuse me, after he believed the respondent was engaging in unlicensed activity. Our investigator met with the respondent, who stated it does not sell or install any alarm systems. The respondent is a low voltage wire contractor, and when it has clients that need alarm systems, it contracts that work out to a licensed contractor. The licensed contractor who it works with is actually affiliated with the respondent and is duly licensed with this board. Respondent is licensed as an electrical contractor, although it has not requested an exemption from this board regarding licensure. Based on the respondent's statements and the review of its website, it does not appear to be offering any services as an alarm systems contractor. The recommendation is to close.
This is Lou. I'll make a recommendation to close. Agree with council and close.
Second by Scott.
All right, we have a motion and a second.
Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richards.
Yes.
The ayes have it to concur with council.
Okay, thank you. Number 3, complaint number 20200541141. The summary is the complainant entered into a contract with the respondent in May 2020 for an alarm system installation and monitoring. The complainant stated he started having issues with the alarm going off in June 2020, and that when he called the respondent about the issues, he was told there would be a service charge. When he asked about canceling the contract, he was told there would be a termination fee for breaking the contract, as he's under contract for a 5-year term. The complainant alleged that he was unaware of the early termination fee and was unaware that he was under contract for a 5-year term. The respondent disputed that it did anything improper, however, it agreed to terminate the complainant's contract. Therefore, the recommendation is to close.
This is Scott. I'll make a motion to close.
This is Lou. I'll second.
We have a motion and a second.
Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richards.
Yes.
The ayes have it to concur with council.
Okay, moving on to number 4, complaint number 20200544401. The summary is the complainant stated he had attempted to cancel his mother's contract with the respondent, and the respondent was delaying the cancellation process. The respondent canceled the contract and stated the delay was due to the complainant not wanting to have any contact with the respondent or other than via email. There were also delays due to the complainant's lack of authorization to make changes on his mother's account, as well as not knowing her password to her account. In total, it appears to have taken a little over a month for the account to officially close, and it does not appear the respondent acted unlawfully in closing the account. The recommendation is to close.
This is Scott. I'll make a motion to close to concur with council.
This is Lou. I'll second.
We have a motion and a second to close.
Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richards.
Yes.
The ayes have it to concur with council.
All right, number 5, complaint number 20200060991. The summary is the complainant was under an alarm monitoring contract with the respondent in July 2020 when she began having issues with the system malfunctioning. After deciding she was going to move before the system was serviced, she was told her home's buyer could take over the contract, or she could pay off the remaining 30 months of the contract. After receiving the complaint, the respondent agreed to cancel the complainant's contract as a gesture of goodwill, as long as the complainant returned the new equipment she received in February 2020, and to refund the last payment that the complainant had made in August 2020. Just for clarity, that was the respondent refunding the last payment to the complainant made in August 2020. The recommendation was to close.
This is Lou. I'll concur with counsel and recommend close.
And a second by Scott.
We have a motion and a second to close.
Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richard.
Yes.
The ayes have it to concur with counsel.
Okay, thank you. Number 6, complaint number 2020063711. The summary is the complainant contracted with the respondent for alarm monitoring services for May 2014 through May 2019. The contract had a 12-month auto provision that would go into effect unless the complainant sent written requests to terminate the contract at least 30 days prior to the contract's term ending. The complainant stated he tried to terminate the contract through mailing a letter and sending an email to the company, and that they sent him another bill. We didn't have proof the complainant followed the exact steps of the contract and was still being charged. However, the respondent agreed to terminate the agreement without further cost, so the recommendation is to close.
I make a motion to concur with counsel and close.
This is Lou. I'll second.
We have a motion and a second to close.
Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richard.
Yes.
The ayes have it to concur with counsel.
Okay, thank you. Number 7, complaint number 2020067401. The summary is the complainant entered into a contract with the respondent in July 2019 for alarm monitoring services that contained a provision that the complainant's monthly rate would not change until after the first 12 months of service. At the 12th month of service, the complainant received a bill that was $7 higher than usual. She called the respondent and they agreed to refund the additional $7 that was billed. The same issue appeared to occur the next month, and the respondent agreed to refund the entire balance due for that month, as well as to keep the monitoring rate at the original amount. The respondent may have breached its contract by increasing its monthly monitoring at the 12th month of service instead of waiting until after 12 months of service. However, it appears the respondent has taken appropriate steps to compensate the complainant for this situation, although the complainant appears to want a full rescission of the contract without any early termination fees. This issue does not appear to be one on its face involving fraud or any dishonesty, although there may be a breach of contract by the respondent. The board could elect to send a letter of warning regarding this potential breach of contract issue if it believed necessary. However, this case does not appear to rise to the level for formal discipline, so the recommendation is to close.
So the complainant is wanting the contract canceled altogether, but it, how many months was the contract for? Do we know?
I remember she sent the amount that was due under the early termination fee, and I didn't necessarily look at that or calculate that at that time.
Okay. It does all sound like a civil matter. It doesn't sound like anything was done wrong, and the 12th month may have actually even, I mean, that 12th month may have been when they could have increased the price if they didn't bill for the first month. I'm going to make a motion to close.
This is Lou. I'll second.
Hey, we have a motion and a second to close.
Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richard.
Yes.
The ayes have it to concur with counsel.
Okay, thank you. Number 8, complaint number 2020067231. Summary is the complainant entered into a 36-month alarm monitoring agreement with the respondent in January 2019. In July 2020, the complainant entered into a monitoring agreement with another company to have that company take over the previous monitoring services. After receiving bills from both companies, the complainant made this complaint. The respondent stated that the complainant had not paid its last 2 bills and that he had requested a final bill stating that the complainant's new company would be paying off the contract. The respondent stated that it has not received these payments, but in a gesture of goodwill, it would waive the remaining past due balances and terminate the agreement. So the recommendation was to close.
This is Lou. I'll make a motion to concur with council and close.
Second by Scott.
Have a motion and a second to close.
Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richard.
Yes.
The ayes have it to concur with council.
And this is number 9. This is the last case on the legal report, complaint number 2020068971. The summary is the complainant entered into a 60-month alarm monitoring agreement with the respondent in May 2020. A few months later, the complainant put its house on the market and was under contract to sell his home. He contacted the respondent, who told the complainant that he'd have to pay an early termination fee unless the complainant's home buyer took over the contract for alarm monitoring at the home. The complainant then made this complaint. The respondent attempted to negotiate with the complainant to reduce the early termination fee by half if the new home buyer didn't take over the contract, which the complainant seemed to accept. Then the complainant stated it would not agree to a resolution until the new home buyer decided whether it was going to take over the monitoring agreement. The respondent then agreed just to waive all early termination fees and to cancel the contract with the complainant. Therefore, the recommendation is to close.
This is Scott. I'm make a motion to concur with council close.
This is Lou. I'll second.
Have a motion and a second to close.
Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richard.
Yes.
The ayes have it to concur with council.
Thank you. I did have one other thing to bring up. We have a case we've been trying to settle. It is a unlicensed contractor case. Due to we've kind of gone back and forth with it, so we're looking to set it for a formal hearing at the December 17th board meeting. Would you all prefer? I know online it says right now that meeting is going to be held in person. Is that what you all would request for me to put on the hearing in person?
Let me step in if I can there, Jesse. All of them say in person, I believe. I was under the impression that we were still going to do virtual to the end of the year. Now, and then I also was under the impression it might be up to the judge whether whoever, whether we go into office or not.
And that's what I was thinking. I can make that request on there. It may be at the judge's discretion, but since the website was showing in person, I wasn't sure if anything had changed.
Well, we would change that if we're going to be virtual, but that's up to the board. Do you want to go into what he's asking? Are we going to go into the office to do that, or we're going to do it as a virtual meeting through WebEx? Then, like I said, it's a lot of the judges, some of them have their own decision on that. I think he's asking you what your opinion is.
My opinion, this is Keith. When we do hearings, if possible, I like to be able to be in the room with the person and understand what they're saying and see the expressions on their face, and you get kind of a better feel for what's going on in person. But if it's not possible, then we have to figure out another way to do it. But that's my
Thank
preference.
You. Okay. Keith, Scott, how about you?
Yeah, I would agree with Keith. It would be probably better in person, but if we can't, and I'm fine with online.
Lou?
I'll third that.
Okay. So I think, Jesse, the board would like to have it in person if all possible, if the judge will allow that.
Okay, thank you.
Can I just ask the board members if the judge prefers a virtual hearing? I'm just wondering if you all were able to attend any of the APD training, just to kind of get a feel for what a virtual administrative hearing would look like.
I believe Lou was the only one that attended that.
Okay. And I'll see if we have any information we can give out to you guys that may help with that process.
Thank you, Ashley.
I believe they did send out notification that we would do another WebEx with one of the judges, if enough of our people really wanted to. I have quite a few No, I had 3 from the PI board that attended it. And we may be going into a formal hearing with them as well.
Well,
But
well,
if we want to
I
try to
think if
set
we have,
something up,
yeah, I was going to say, I think if we have, some members of the PI commission as well as members of the alarm board, we can try to get them to schedule just a session for you all, so that you have that information before the December hearing.
is that something the board would like to do?
Yeah, this is Lou. I didn't have power that day, so I couldn't actually be on the video conference. I was there to listen, but I'd like to do it again, yes, if possible.
Okay. Keith, you would have a big role in that as the chair.
Right. Yeah, I definitely need to go through that.
All right. Ashley, could you see if you could set that up? Just give me some dates and I can get together with the board members and see when we can do it. Who wants to do it?
Absolutely. I'll start looking into it after the meeting.
All right. Thank you. Thank you, Jesse.
Thank you.
All right. Do we have any appearances?
Let me see here. No. Let's go to, yes, I want to make a statement. It probably could be under old business, but you remember the last meeting we had a young man that attended by the name of Jamie Langston. You wanted to get some more information. Oh, we wanted his qualifying agent to appear. All right. I have since received a termination notice on this gentleman. So I made a telephone call to him because he would still be eligible if he was approved to be working for another alarm company. And he said no, he wanted to drop his application to close it altogether.
Okay.
Because you requested his reappearance at the meeting today.
Right. Okay. All right.
I think we're down to my matters now. If I can go ahead with that, you want me to, Mr. Chairman?
Yes, please.
All right. You have your monthly report. You have August and September. So if we go straight to September, we still have a vacancy on the board. And it tells you here that we met on September the 9th. We did do our financial meetings as well. If there's any questions about that, I can answer that. If not, I'll just move right on to the budget review. And there's something you don't have. What you have in front of you is the year ending. Remember the one that I gave you at the last meeting? I told you I'd get like 3 or 4 ending budgets. Well, this is the final budget for the Alarm Systems Contractors Board. And you ended with a year's total of $52,215 in the black. What you don't have, I don't believe, is this month. We went, July starts a new year. We start with a 0 balance. We have July, we have August. And right now, at the end of August, you have $27,654 in the black. So I don't think we have an excessive amount, but we have enough to continue running the board with this. There was some little bit of drop in revenue, but that was we actually expected that. And the expenses, you go like to a formal hearing, anything of that nature, and large investigations, that's where the fee goes up for the investigations and for our legal as well. But for 27,000, I think we're holding our own starting the new year. Is there any questions about that?
Nope.
All right. Legislative updates. We don't have any. Simply just don't have any. We haven't heard from the Hill. Sometimes no news is good news, but we still haven't heard, but we are prepared. Request for an extension. We did not have one. We do have a criminal history review. This one here was just a little different. This gentleman here is John Waddle. He is he's going a registered employee, and he's going to be a sales person. We'll give you a few minutes to kind of look through that because it's kind of lengthy there. You just go back to his record here. What I could determine, he was guilty of battery on 2 counts. he was sentenced, of course, to a felony for 12 months, and he's 10 years of probation. He also falls under the First Offenders Act for count 3 and 4.
And so, Cody, looking at this particular criminal history,
Mhm.
This applicant is still on probation, if I'm reading his documentation correctly. Is that fair?
Oh, well, he's on
Yeah.
probation for 10
I just want to
years.
make sure I wasn't. I just want to
Yeah.
make sure I wasn't missing something.
Oh no, it was the Superior Court, state of Georgia document. I talked to this gentleman yesterday and told him I do not have a written explanation from him. I don't have anything from the qualified agent, and I would really like to have those two things to present to you today. Or you may decide if we do not have that information, he'll have to go on to the December meeting. I did talk this over with Jesse due to this length of probation, and we both agreed to bring this to the board and let you take a look at it.
Cody, under normal circumstances in the past, I think with a person being on probation, we usually try to wait till that probation is over before we grant a registration. Typically,
Yes, sir. Well, this person won't be working in the business for another 10 years.
well, we get ourselves in that position, I guess.
Do you have any other comments from other board members?
I mean, I have the same concern. Did the person actually, they did serve, they were incarcerated for 12
For
months?
12 months. Yes, on concurrent on count. It says, look here, like it says, it ran concurrent with count 2. That's why I told you count 3 and 4 was the First Offenders Act. So they took that off. It's just what we're looking at right now is the 10 years of probation.
Now, all I see is just one page of that's as far as court record or anything. You said about other counts. It's lists like count 1, count 2, but
Right, but on the criminal records that you do not see, that I'm not able to give to you, it does say there were count 3 and 4, and they went under the First Offenders Act and were removed.
okay.
But it was for the same thing.
Okay.
I guess my question is going to be to legal. Can we hold somebody from getting a license or is on probation for 10 years? We are seeing more of this.
Right. Well, if you're going to deny it, we have to do a fresh start analysis,
start.
of course.
Mm-hmm.
I guess my hesitation with this particular applicant, and you've mentioned it, is because there is no statement from him, and there's no letter from his potential QA. But like I said, if the board looks at that and considers that in regards to fresh start, and we have that analysis, and they decide to do that, decide to grant it, they have the authority to do that. But if they're going to deny it, of course, it has to be after that fresh start analysis as well.
Well, I think also the how new that this is. This is not an old case. I mean, it just happened this year, so I think that would carry a lot of bearing on it as well.
I think the offense was back in 18, because he served his year.
Okay.
Now he's on probation. If you look at the document up at the top, almost about middle ways, you'll see where it has date of offense on December the 15th, 2018, date of settlement, or whatever that DOS stands for, 2/5/2020. That is new, but it's actually a 2-year, already 2 years old.
Gotcha. Okay.
You want to be 2 years old. Well, actually, under the Fresh Start Act, can we deny this individual based on the fact that it is a relatively new offense and due to the 10-year probation?
Right. And I think that that's probably just one factor, well, one or two factors. If you look at the length of time, of course, we said it's only a couple of years old. I guess evidence of rehabilitation you could sort of weigh his being granted probation in that. I think the board still needs to look at the crime that he was convicted of and his ability to be a registered employee, a salesperson in particular, and why we choose to regulate the registered employees and the salespeople, the salespersons. And then, of course, the nature and seriousness of the crime. And if the board could just speak to that before they make their decision, I think that will cover their fresh start analysis.
Okay, so this gentleman here has been charged with, from what I can see, several counts of battery, even though a couple of them were technically dismissed.
And I think that's where his personal statement would have provided some clarity. Was this one incident? Like, how did it get to so many counts? But we don't have that, so we can only, analyze what we have in front of us.
So can we ask for that for the next meeting?
Yes, you can.
Yeah.
Do you think that will change your opinion one way or the other, or are we today where we're going to be at that meeting as well?
Mm-hmm.
Personally, right now, I would be inclined to deny with the information we have. If, without other information, we don't know, but it is concerning that this is a salesperson. He'll be in, someone's home alone with them. We don't know the temperament of the situation. It does say it was family, but I would have concerns. My inclination would be to deny. I know what you're saying. It's like, well, we'd be in the same place with an explanation, but we don't know what the explanation would be.
Yeah, after being over salespeople for 30 years, I would hate to know that I had a salesperson in a customer's home that has the capability of committing these crimes so recently. So that would be my concern. I don't know what an explanation of any type would change my opinion of that.
Lou, do you have a comment?
No, I'll make a motion to deny the applicant.
Second by Scott.
We have a motion and a second to deny.
All right. Keith Harvey?
Aye.
Scott Cockcroft?
Aye.
Lou Richard?
Yes.
Motion carries to deny this registered employee's application. All right. That is actually the only one that we had. Now we're going to go down to the section for education, the education review. We sent this information out to Doug Fraker, this course. He did contact me, like I told you, his mother passed away, but he was able to look at the course, and he is saying the same thing that I did. He looked at the course, but he felt like all they provided was an outline. And looking at the course itself, it said it wanted 2 hours for Berg Fire, CCTV, and monitoring, but all it's talking about is an emergency and a business plan. I didn't know if that would be even eligible for 2 hours in each one of those classifications. So what he's basically saying is no. He didn't want to approve this. I felt like we need more information. And again, I'm going to tell you, it is by Alarm Monitoring Services Incorporated, because I don't believe you have that in front of you. They are on the course list. But what they have provided is just one page that says 30 minutes for what's an emergency, 30 minutes for creating a business contingency plan, 20 minutes for emergency action plan, 10 minutes for things that could go, and 20 minutes for solutions. A one pager, that's all there was to it. Well, I take that back. Now they did provide the certificate, copy of the certificate.
Okay. Well, just some background. I mean, I know the company. I mean, I've been to their uh, training before, and they contract services. I mean, they do a good job. Dara has done the training in the past, and then this is says the instructor on this is Michelle, that used to be with CenturyNet, and then I've taken classes from her. I would vouch for both the company and the person, but we don't have a lot of information. Maybe just a little bit more information, and we could approve it.
Yeah, it doesn't tell me when they want to have this course. Of course, you don't meet again until December.
Right.
But it doesn't say.
I think the topic is good. I mean, it's important for a business to be able to maintain in a disaster, and I think that's applicable to Firebird and monitoring. We've done some other things that are maybe stretching even more so on. So I think the topic's fine. Maybe just a little more information.
What more information do I need to ask for?
I don't know what was I mean, if they have a PowerPoint or something that they're going to use, possibly, or any other documentation they're going to give out. That's what Doug was just wanting more detail on what they were doing, right?
Yes, yes, sir. That's all he said. Was provide more. All they provided. They need more than he needed more than just an outline to see what we have.
Right.
Some of those companies will send in almost a transcript of the course. You know, something like that would help
Right.
if they have it.
Oh, okay. So is it the consensus that we're going to hold off for approval here? And let me get some more information and bring it back to the December 17th, I think it is, board meeting.
Yes.
Can I get a motion for that?
A motion to postpone this to the December meeting?
Yes. Scott?
This is Lou. I'll second.
All right.
Have a motion and a second to postpone.
All right. Keith Harvey?
Aye.
Scott Cockcroft?
Yes.
Lou Richard?
Yes.
All right. The ayes have it to postpone a decision on this course by American Monitoring Services. Would your business survive if, and to bring it back to the December board meeting? All right. Got that. All right. That's all I had under the education. And for unfinished business, we need to vote on our new course, our new dates for the 2021. And what the dates are: February the 26th, April the 16th, June the 25th, August the 20th, October the 22nd, December the 17th. I will need a vote on that, please.
Can I get a motion?
Does anyone have any issues with those dates?
They're good with me. I'll make a motion to accept the dates.
Did he make a motion?
Yes, he made the motion to
Okay.
approve.
Second by Scott.
Okay. We have a motion and a second to approve the dates as presented.
All right. Keith Harvey?
Aye.
Scott Cockcroft? Lou Richard? Lou? Did anybody hear him? Lou? I think that was a yes. Okay. All right. Then motion does carry for the new board dates for 2021. New business. I didn't have any new business, and unless somebody has something else to discuss, Mr. Chairman, I would move for adjournment. Get a vote.
Okay. Get a motion to adjourn.
It's Lou. I make a motion to adjourn.
Second by Scott.
We had a motion and a second to adjourn the October 22nd board meeting.
Keith Harvey,
Aye.
Scott Cockcroft,
Yes.
Lou Richard.
Yes.
Motion carries to adjourn, Mr. Chairman.
All right. We're all done.
Thank you. We'll be talking to everybody later.
All right.
Have a good.
Thank you. Have a good one.
All right. Bye.
Bye.